Uh, Good evening. It's 8 o'clock here in Washington, D.C., 7 o'clock in Chicago, where our guest is joining us tonight, and 5 o'clock on the West Coast. My name is Chip Gibbons, and I'm the Policy Director of Defending Rights and Dissent. At Defending Rights and Dissent, we have long supported your right to know and your freedom to act. This has entailed standing up for those persecuted by our government for the crime of truth-telling. Defending Rights and Dissent organized the first protest calling for the freedom of Chelsea Manning, and we mobilized our supporters for the commutation of her sentence during the waning days of the Obama administration. We organized street protests after Snowden's revelations, and we even dropped off petitions at the Department of Justice calling for the charges to be dropped against Reality Winner. We've circulated statements signed by journalists, whistleblowers, and civil society leaders in support of FBI whistleblower Terry Albury and drone whistleblower Daniel Hale. All of those people were whistleblowers shamefully prosecuted under the Espionage Act. The war on whistleblowers, as a war on journalist sources, were always a de facto war on journalism. The Trump administration, however, has taken this one step further. They have indicted a journalist under the Espionage Act. They've indicted WikiLeaks founder Julian Assange, making him the first person ever indicted under the Espionage Act for publishing truthful information. This is made all the more obscene by the fact that the information Assange published was about U.S. war crimes and abuses of power. To discuss this matter, we are joined again by Kevin Gozstola. Kevin is the managing editor of Shadowproof, and his daily reports on the Assange extradition hearing have been essential for my understanding of what's been going on, and I suspect essential for a lot of you. Kevin, thank you for joining us again.
Yeah, thanks for having me.
Kevin, in a minute I want to get into the crux of the extradition hearing, but first I want to ask you about the media coverage of this trial. There was a tweet, we were laughing about it in the virtual green room beforehand, and you fact-checked the tweet and said it was correct, that said that you've reported more on the Julian Assange extradition trial than the New York Times, Washington Post, BBC, ABC, CBS, NBC, Fox, CNN, and MSNBC have combined. Now, to be clear, there's no one I want covering this hearing more than you, but there has been, outside the independent media, a disturbing blackout. As someone who has covered not only the Assange hearing, but also Chelsea Manning's court-martial and the war on whistleblowers more broadly, what do you make of the media's coverage of the Assange hearings?
So you put me in an awkward situation because I benefit from the lack of media coverage. It means that mostly everyone is going to come and read my reporting, and then they're also going to read other independent journalists reporting. So I do view this blackout as a grand opportunity to show that independent media and alternative media can do as good a job, if not better, than the corporate news outlets or the media establishment. I do think that we may be wasting some time trying to convince them that this is a priority, that they should care more about Assange. At the same time, we all exist in the same country and the world, and we will all suffer if this precedent is set where the U.S. government can prosecute Julian Assange under the Espionage Act and anybody else like him in the future if there is a conviction that is achieved by the Justice Department. So we should continue to struggle with the editors of these newspapers and the media producers that work at networks like CNN. We should continue to struggle with them and convince them that it is as significant as Jim Acosta being tossed from the White House press room, and because they no longer want to grant him access to ask his questions of the White House press secretary. So this to me is a fundamentally important press freedom case, which I know we'll get into. I think that there are a combination of reasons why there is a lack of interest. I'll note first off that there are a ton of things happening right now. You know, we're still in the middle of a pandemic. We've had a lot of overload when it comes to stories, but that doesn't excuse it. I'm just trying to say that with the news media economy and people strapped for resources, I understand why some outlets would not commit to this or feel like they could figure out how to commit to this. That said, the other issue is a lot of people who run these organizations have no solidarity for Julian Assange. They don't see him as one of them. He is, the best way to describe it is he is not the good reporter like who they are in DC. They'll call up the State Department or the Pentagon and ask, what can I publish? What will you allow me to publish? If I publish this, will it jeopardize national security? Will it cost our U.S. foreign policy objective if I expose this detail? If I challenge this, will it cause some kind of scandal that will be disruptive? And Julian Assange isn't someone who's going to do that. He was concerned about the lives that could be put at risk, and he was willing, we heard evidence, to contact the State Department and Pentagon and work on files. But as far as content goes, he's not going to call up and say, what's your policy interest? Why shouldn't I publish? Convince me not to publish this. Convince me that this program is useful. And that's how access journalism tends to work. Yeah.
Yeah, and we are going to get into the free expression as well as the larger human rights issues. I believe there was testimony about the implications of WikiLeaks releases for Guantanamo at the hearing. There's a couple of preliminary things I want to get out of the way at the beginning. The second of which is the last time you spoke to us in March, Assange was indicted then, as he is now, under the Espionage Act and the Computer Fraud and Abuse Act. But between the last round of hearings and the most recent round, the U.S. government issued a new indictment, something I've had some difficulty wrapping my mind around. Could you explain briefly what's in this new indictment and how it differs from the previous one, and what, if any, significance there are to these differences?
So what's important to say before we get into this is, because it came a matter of weeks before the extradition trial, and it really was a trial. It's not just a hearing. This was the evidentiary portion of the extradition hearing that involved calling witnesses. So it's appropriate to call it a trial, even though we would think of the trial as when Julian Assange will be brought to the United States. But essentially, if this plays out, he's going to have two trials, where one, you have the defense put on their case for why he shouldn't be charged, and then later it's going to be the opposite, where in the U.S., the prosecution would be making the case for their charges. And so they had no opportunity to introduce evidence or to call witnesses on this superseding indictment, this latest one with these allegations. And you're right that it is confusing, and there has been a very small amount of attention to this. We've had coverage of the initial computer crime charge. We've had plenty of coverage and uproar over the Espionage Act charges, but I don't think people really understand what's happened with this new indictment that was announced at the end of June. And so what it is essentially window dressing. It, to me, is an admission that they lack evidence for proving that Julian Assange worked or conspired with Chelsea Manning to crack a password. Remember, that is the crime that was first he was first hit with. That was the first indictment from March 2018, was that charge. There weren't any Espionage Act offenses. And so the superseding indictment, this latest one that forms the fresh extradition request, has allegations in there about Julian allegedly helping LulzSec members who were later convicted of offenses. This was a hacking group that was involved in activity in 2011 and 2012, I believe. It alleges that he himself was conspiring to intrude upon government computers that outside of the specific charge around Chelsea Manning. It alleges that he was recruiting systems administrators in national security agencies to leak classified information by speaking at conferences. There are unindicted co-conspirators that are named in this new indictment. One of them, who I suspect and name as Jacob Applebaum, was representing WikiLeaks at these conferences. So it suggests that Assange had people working for him who were trying to recruit leakers for WikiLeaks. This is part of the criminalization of soliciting sources to provide information to media organizations, which is a standard practice among the news media. And so you look at these allegations and you go, why are they doing this? What does this mean? And you recognize, too, in reflecting on it, that it bears no resemblance to the original charge. It has moved so far from what it was originally that now I can even look at the indictment. I think, the legal minds that are part of this group and following this webinar will appreciate this. If you look at it, the way they have charged it has changed. It used to be under the Computer Fraud and Abuse Act, but now you see that it's primarily under this 371 statute, conspiracy to defraud the United States government, which is about as old as the Espionage Act, if I understand correctly, and a highly political kind of an offense that could be brought against an individual. And it's gone away from being a specific computer crime charge. It's now a more general thing of, we think he's talked with hackers. We don't think that should be allowed. That is a conspiracy against the United States. It's a conspiracy to disrupt the U.S. government. So basically, he's being criminalized for talking with sources who might be able to provide hacked materials. There's no evidence in there that he participated in hacking. It's just this idea that if he was provided hacked materials, that should be somehow a crime, even though we have a clear ruling in the Southern District of New York by Judge John Kodal in a case that the Democratic National Committee brought when they were going after the Trump administration and alleged Russians as well as WikiLeaks for publishing the Podesta emails. And a judge ruled that you have a First Amendment right to publish hacked materials. It doesn't matter who it came from or whether those people were engaged in crimes. Journalists have a right to publish.
And there was a Supreme Court case that I'm recalling from First Amendment law where a news outlet received some sort of conversation that was the fruit of legal wiretapping, but they broadcasted, and the Supreme Court upheld their right to do so. News outlets can, under the First Amendment, publish information that was illegally obtained. They just can't legally obtain it themselves.
Mm-hmm.
So I have one last question before we get into the meat of the hearing or trial. So the legal system is very Byzantine, as you know, and this involves two countries' legal systems at this moment. Could you just briefly explain where we are at in the process of prosecuting Assange, what this hearing is about, and who are the parties involved in it? Is it the U.S. government? Is it the British government? What's going on for those of us who maybe haven't followed it that closely?
The Crown Prosecution Authority represents the U.S. government and agrees under the treaty to take up extradition cases and bring them before the judge to litigate them on behalf. They're not necessarily defending the U.S. government, but they're given the best case that the U.S. claims to have. Well, I don't think it's that good of a case, but they try to convince the judge that they have reasonable suspicion to believe that a crime has been committed. And if the judge is persuaded that a reasonable suspicion exists for any of these 18 counts, he will be extradited. What I'm not entirely certain about is I don't think they have to prove all 18 counts for the extradition to be authorized. I think she can throw out counts. And then you could have a scenario where they throw out, let's say, half of the counts, and then the other half, she says, well, there is evidence that that's a crime, and that matches up with the U.S. So then there is a rule that what's alleged as a crime has to be a crime in British law, I believe. That you have to find commonality. And so then that's where you get into issues with the U.S. and U.K. extradition treaty over whether political offenses have been alleged or not. And something that the defense spent a lot of time on is arguing that Julian Assange is being targeted for his political opinions, and also that the Espionage Act is a political offense since it involves a crime against the U.S. government. And it would be really difficult to go after somebody in the UK for committing a crime, for opposing the US government or for doing this, because they're not a US citizen, and then also it wouldn't be a crime to oppose the US government in a foreign country in this manner, in the way that it could be criminalized in the United States. And so at this stage, she is going over the material. There are closing argument submissions that are being provided to her over the next month from both the defense and the prosecution. We know that on January 4th, 2021, there will be a decision on whether to extradite, and then there will be the first appeal. The first round of an appeal will begin.
Wow.
And so that'll either come from the government or it'll come from Julian Assange's team. But I treat this as inevitable that there will be appeals.
Yeah, I think that's probably correct. So a number of human rights activists have testified on Assange's behalf, including the founder of Reprieve UK and Andy Worthington, a journalist who's been involved in exposing abuses at Guantanamo Bay. What was the defense trying to argue by bringing these human rights activists forward, and what did these witnesses tell the court?
Yeah, so the focus on the publications involved the argument that WikiLeaks, or Julian Assange as the publisher, exposed U.S. crimes or criminality. This is similar to saying, when whistleblowers do their exposures, that they've exposed waste, fraud, abuse, and illegality. And to say that essentially the U.S. government is retaliating against Julian Assange for exposing war crimes and torture, etc. And they have a pretty good case, actually, because there were two concrete examples. This wasn't really part of Andy Worthington's testimony. He had some good statement. He had a good statement to provide to the court about the Guantanamo files, which were the detainee assessment briefs that Chelsea Manning provided to WikiLeaks, which documented how, if you looked at the 700 plus people who were brought to Guantanamo, they weren't the worst of the worst. They were, maybe a handful of people who you could say were actually even guilty of being involved in terrorism. The rest were, the victims of bounties that were put out for them. And there were people who were coerced into giving false confessions. And a very small universe of those people, they basically told lies that helped the U.S. government justify keeping them in indefinite detention. And so that was Andy Worthington's testimony. But then I think more importantly, there was what Clive Stafford Smith had to say. He was one of the founders of Reprieve UK, who was called to the stand. And he described how cables that were published by WikiLeaks helped win a ruling in a Pakistan high court that essentially led to the complete subsiding, if not total, end of drone strikes in Pakistan, as the court recognized that those were war crimes on the part of the United States. And he represented survivors or families who had lost loved ones as a result of U.S. drone strikes. And then now he's pursuing, on behalf of at least one or two Guantanamo prisoners, pursuing a case before the International Criminal Court that relates to that relates to war crimes that were committed in Afghanistan. And then you have Khalid al-Masri, who testified, and he himself is a survivor of CIA rendition and torture. And it was quite crucial to hear his voice. Well, we didn't hear his voice, but to have him submit a statement, because he walked us through what happened to him and he outlined how WikiLeaks disclosures in the cables about the U.S. government pressuring Germany not to prosecute the CIA team that abducted him, how that helped him win some small level of justice at the European Court of Human Rights against Macedonia, who was implicated because that was where he was detained and then handed over to the CIA team that abducted him. And right now, this is really crucial point to focus upon, because this came up multiple times during the trial. The International Criminal Court is pursuing an investigation into war crimes in Afghanistan by all parties involved in that war: the Taliban, the Afghan government, Afghan-backed militias, the U.S. military, coalition forces, anyone involved. They're doing an investigation. There have been people who have brought evidence of crimes on the part of the U.S. government, and they were sanctioned. These leading investigators at the ICC who are involved in this have been sanctioned. And that case, there are materials that WikiLeaks exposed that are being used by the ICC in this investigation.
That's a really important point, and I think it really drives home the fact of the importance of what Julian Assange did and what WikiLeaks did. You don't always get a good impression of him in the media. But he is someone who has exposed human rights abuses and has exposed war crimes. Of course, free expression is also a human right, and Assange's trial has huge implications for the future of free expression, both in the US and globally. I know both Pentagon Papers whistleblower Daniel Ellsberg and press freedom advocate Trevor Timm testified. What types of arguments did they make, and how do the free press questions weigh in the British government's consideration of the extradition request?
Right. So Trevor Timm, he had some really good points, and it's important to understand that up until Julian Assange, journalists had only been threatened with prosecution under the Espionage Act. So you take people like James Bamford, who we know for his work on the NSA. There's Ben Bradley. Seymour Hersh is a very well-renowned journalist. Neil Sheehan, who was involved in the Pentagon Papers. These people were threatened with prosecution. You even have Beacon Press, as they were publishing. So after Mike Gravel read the Pentagon Papers into the record, they were willing to publish the Pentagon Papers and distribute it to the public, and they were threatened with prosecution. But you never had charges actually be issued. And so Trevor Timm, what he did was put a focus on this move that Donald Trump's administration has made to prosecute and explicitly criminalize national security journalism and what it means for the wider press. And to describe how WikiLeaks was a pioneer in developing a way for journalists in the 21st century, in the digital age, to receive anonymized submissions from people who want to expose government abuses and wrongdoing. And he himself has worked on a system called SecureDrop, modeled, I think, after the kind of open source platform that WikiLeaks developed. There are organizations throughout the mass media that use it. In fact, more than 70 organizations, the New York Times, the Wall Street Journal, the Associated Press, USA Today, Bloomberg News, CBC, the Toronto Globe and Mail, these were some of his examples. All of these outlets have these secure drops, and they are soliciting leaks. There's even the International Consortium of Investigative Journalists that is well known now because of the Panama Papers investigation they did, and they have a page on their website that says "Leak to Us." So he was highlighting how, this is fairly common what we're doing. And as he was, as the prosecutor, the lead prosecutor, whose name is James Lewis, as he came at Trevor Timm, one of the things he wanted to suggest is that there was irresponsible journalism that was conducted on the part of Julian Assange, that he endangered informants or confidential human sources that were working with the U.S. military, and that he did something that should be criminalized. And Trevor Timm made it clear in his testimony, I think he's one of the only people who made this point, that it is not a crime in the United States to publish the name of informants. It's just not. There's a difference between what's responsible journalism and what is illegal journalism. It's very important to make that distinction. And he pointed out that Joe Lieberman and other senators, a very small grouping, tried after the WikiLeaks publications to push something called the SHIELD Act. That was the acronym that it formed. And they wanted to make it a crime to publish for anyone to publish the names of human intelligence sources. But it didn't pass. And what that tells you is it wasn't that important, or that it ran up against First Amendment hurdles. The same hurdles that led President Barack Obama's Justice Department to decline to indict Julian Assange back in 2013. And so that's a clear point to make. Another thing I'll say quickly here is that Daniel Ellsberg's testimony was tremendously powerful to hear. And of course, he's done webinars with you before. I mean, I did a webinar with him. And he himself really took on the prosecutor's effort to draw this false dichotomy. He's constantly been used in his lifetime, and he's well aware of it, how he's been treated as the good leaker. And even though Julian Assange is not technically a leaker, they treat Julian Assange as the bad leaker, or Chelsea Manning's the bad leaker, or Edward Snowden's the bad leaker. Well, he says there's no difference. And he very clearly described for the prosecution that when he released the Pentagon Papers, he did not make a single redaction in those papers. He left names in there of people who were potentially vulnerable. He even left in the name of an undercover CIA officer or a officer that was in Vietnam, and anything to be redacted because he didn't want anybody to look at black bars on the page just to the media. That behind those black bars was dedication, a real justification for being at war in Vietnam. So he did not take care with the documents and remove names in the way, and so he's as guilty as Julian Assange is when it comes to handling the Pentagon Papers. And yet people treat him like he did everything that was inappropriate.
So my understanding was that there was some controversy during the trial about exactly what happened with the redactions and who was responsible for the unredacted versions of the WikiLeaks documents or the State Department cables being online. Could you speak to that a little bit, or is my understanding off?
No, you're correct. So the allegation that has been brought, and it's in the indictment, is that WikiLeaks, or Julian Assange, since he's the one that's on trial, published unredacted cables. The entire cache of over 250,000 cables were posted, and then informants and other people were endangered because these were published. But what happened was the book that was published called Inside WikiLeaks by David Lee and Luke Harding of The Guardian, they used as one of the chapter titles the password for this file that was on the internet. And the file contained the entire cache. And what happened is there were journalists were putting two and two together, figuring out that this file they had found and this password in the book linked, and that it could open the file. And there was sleuthing that was going on by bloggers on the internet. And at some point, it was clear that they had complete control of this file, even though there was no the contents yet. What we heard was evidence that there was country by country media partnerships that were still being organized, and there was potentially another year of coverage of the evils if this happened. Because what that scene was transition away from dumping to very careful curation with WikiLeaks and media organizations within specific countries so that reporting could have high impact and perhaps lead to reforms even in those countries. And then essentially what happened is because of this very stupid mistake on the part of David Lee and Luke Harding, this very reckless thing that completely flouted any guidance or guidelines they had been given by WikiLeaks on how to handle the material, publishing a password for an encrypted file. Because of this, it was loose. But they also weren't even the first to publish the unredacted cables. It was entered into evidence that Cryptome.org, a well-known site for publishing leaked documents, had the entire cache published before WikiLeaks even did anything to publicize or post these cables.
So in addition to the Espionage Act charges, as we've mentioned, there's also the computer fraud and abuse charge. You've stated that you thought the government's case fell apart on this charge. Could you
hold on. Do I have a connectivity issue, or are people having trouble? Do you want me to come back? I don't know what that would be, but I'm seeing that somebody suggests that. Oh, okay, cool.
You're good now. Technical difficulties resolved without even doing anything. That's always the best way. So what I was asking about was, you've said the cracking case, the charge has fallen apart. Could you tell us a little bit about how the government stumbled at the extradition hearing?
Yeah. So what happened is the defense found an extremely good witness that they could put on the stand to pick apart this allegation, which is important to know that when the first indictment came out, there were press freedom advocates and there were also legal minds who looked at this and said, that's narrowly tailored. It actually avoids the broader legal and policy implications that we think could occur if he was charged under the Espionage Act. And so this is one way to go after Julian Assange without jeopardizing the First Amendment and press freedom. They were totally wrong. But I want to point out that this charge was sort of what softened everybody's minds when it came to whether or not Julian Assange deserved to be prosecuted. And you saw a fair amount of people accept that the Justice Department had grounds to go after him. So they bring this guy, Patrick Eller, who has a history as a digital forensic examiner. He worked in the U.S. Army Criminal Investigation Command headquarters in Quantico. And it's possible that he had even worked with people who were involved in piecing together evidence at some point for Chelsea Manning's prosecution. He looked over the court-martial record and examined it, and he picked apart the deficiencies in what the U.S. government is arguing against Julian Assange. And what he said is, at the time, it would not have been possible to crack an encrypted password hash such as the one Manning obtained. So without getting too far into the technical weeds here, there were numbers that were given. It's a password hash, and supposedly the series would be useful in cracking this password. You need two files, and there was only part of one of those files that was ever provided to Julian Assange. If we believe that Julian Assange is on the other end, that's the other problem, is that all we have is what we had during the 2013 trial, which is evidence that some account called Nathaniel Frank that had a Jabber account, this Nathaniel Frank Jabber account, was chatting with Chelsea Manning. But they still don't know if Julian Assange was on the other end and operating this account. So we know this Nathaniel Frank account communicated, and Chelsea Manning provided part of one of the two files. It's not enough to crack the password, and that's really all we really need to get into here. But there's also alternative explanations for why she would have asked about cracking the password. In her unit, people were constantly downloading unauthorized music, movies, and programs to their computers. She had talked about starting a password cracking or a hash cracking business. So there are other explanations, and it's possible that she wanted to get this password, wanted to find a way to hack into her computer so that she could so that she could download these programs without being detected. That's another explanation. And so he even said very clearly, Patrick Eller did, that there are alternative explanations for why they might have had this conversation that don't relate to the leaks. She already had access to the documents. She did not need Julian Assange's help to get into the U.S. government's computers.
That's really helpful and illuminating. So in addition to the human rights and free expression issues, one of the big themes of the hearings were issues pertaining to Assange's health, as well as conditions in the U.S. prisons. I want to be sensitive about the health information. I know it was brought up. I'm just going to acknowledge it. But I do want to go into details about the issue with U.S. prison conditions. What did witnesses testify about U.S. prison conditions, and how have U.S. prison conditions been implicated in past extradition cases?
Yeah, so let me just say that I was sensitive as well to the medical health issue, the different data and thing. I didn't actually put out anything when I was reporting on what specific medications he was taking, and I recognized that some of this didn't have any bearing on whether he was extradited or not, and it didn't really need to be shared. But one thing that was important to me because there are 2 prior cases that are relevant. And because one of his attorneys is Edward Fitzgerald, who is a barrister who was was on the legal team for Lori Love. So it's important to point out that he was Julian Assange, while he was at Belmarsh prison, was diagnosed with autism. And this is important because in the past, there are 2 cases that were brought against hackers that led to their extraditions being blocked. This is Gary McKinnon and Lori Love. This is in the last decade. Their extraditions were blocked because they were diagnosed with Asperger's syndrome, and it's because they're the court and then Teresa.
Okay, I think we've lost Kevin. Kevin?
Hey, I'm
Froze
back.
up for a second. Okay, you're back.
Yeah, I don't know what's going, but if you think it's gonna make things run smoothly, I can leave and come back to this entirely.
I think we should be good. It's only occasionally. Could be
Okay.
global.
It's really odd that this is going on. Okay. Are we good?
Yeah, we're good.
All right. I don't know where you lost me there.
We're talking about 2 cases brought by the same barrister in which Asperger's syndrome had bearing.
Okay. All right. So there's a barrister named Edward Fitzgerald, and he was on the legal team for Lori Love. And then Gary McKinnon's case. So Gary McKinnon's case was blocked by Theresa May when she was Home Secretary. And there was the court, one of the courts, and then during an appeal, and then there was the Home Secretary. And they both recognized that the Supermax prison in Florence, Colorado, and even the prison system in general would expose both of these men to cruel and inhuman treatment if either of them were extradited to the United States. And so this came up. This was a focus. We examined the pretrial confinement conditions that Julian Assange would be subjected to. It was agreed that he's likely to be held at Alexandria Detention Center. And that facility has already received attention in this case because it was where Chelsea Manning was jailed for a little over a year because she refused to testify before the grand jury that was empaneled to investigate and, in my opinion, destroy WikiLeaks, and had been doing some work in some capacity for most of the last decade. And so we know that there's solitary confinement at this facility at the ADC. We know that high-profile defendants get put in solitary confinement. Without commenting on their cases specifically, Maria Butina and Paul Manafort are both people who were held in solitary confinement conditions, although I do note that Maria would not have been held in the same wing because she's a woman, and we're talking about men here, and so they do have separate units, but they have solitary confinement, and this is something the government would deny, that they actually are putting people in solitary confinement in the ADC. He could be subject to special administrative measures, which would restrict his communications with his legal team and his family and anybody out in the outside world, cut off his exposure to current events, being able to maintain that connection so that he could even be lucid and participate in his defense as well. And then if he's convicted, there's a lot of evidence that he would be sent to the Supermax in Florence, Colorado, and be subject to solitary confinement conditions there, perhaps placed under SAMS as a national security defendant, or he could be sent to a communications management unit in Marion, Illinois, or Terre Haute, Indiana, where they have both of those. And so that there was evidence that was put on the record about this and what prison would probably do to someone like him, who was already deteriorated from his time in the Ecuador embassy and has been at different periods of his detention in the UK gone through either moderate depression or severe depression.
Yeah, and I just want to say about Chelsea Manning's detention. I mean, the detention at at that jail is very horrendous. Defending Rights and Dissent was one of a number of human rights groups who sent a confidential communication. It's never been published to the UN Special Rapporteur on Torture about Chelsea Manning's conditions because they were extremely concerning, and putting anyone in those conditions would be troubling. So could you talk a little bit about what we've learned this time around about some of the surveillance and sort of covert ops that have been done against Assange? I know there were a couple of shocking revelations near the end of the hearings.
So we have two of these anonymous witnesses that worked for a Spanish security company called UC Global. David Morales is the director, and he currently faces a criminal case in Spain for privacy offenses and other offenses. He also was found to have unlicensed weapons. He has ties to the military, and so now he's got arms or weapons against him. So you've got these witnesses who were allowed testimony anonymously. They're living under armed, at least one of them is living under armed protection. And the evidence that we've learned is that there was spy operation targeted against Assange, specifically directed at his legal team. I think significantly Baltasar Garzón, who is known very well as a former Spanish judge. He was on Assange's team, still part of Assange's team, and he was singled out. He was followed by the members of this UC team, and his office broken into. We don't know exactly if that was a UC Global thing, but he had his office broken into after Morales discussed it as a possibility. This Garzón, don't know, was someone who considered the possibility of going after former Bush administration officials for torture and investigating. I think this jurisdiction principle, thing that he believed might be for pursuing.
And he indicted Pinochet.
Yeah, he's very well known, and they targeted him. And we know that the legal meeting high priority, they had to meet in the women's room, and it turned out to be bugged. There were 2 microphones that were planted, and we learned that it could have been worse, but an IT discouraged having cameras that weren't only audio recording, but were also streaming. So it was considered that streaming capabilities. Then there was a consideration to plant a microphone in every single room and use that to spy on Assange. Assange had a white noise machine that actually was fairly effective because they went and put stickers on the windows to help U.S. intelligence direct laser microphones at the embassy and collect conversations. And then we learned that after he was arrested and expelled, we learned this from Gareth Pierce, who is a very renowned and well-respected human rights attorney. She herself said in her statement that the legally privileged materials that were in the embassy were seized by the Ecuador government and handed over to the FBI in the UK. And now they're in the control of the US government. And we have no good reassurances from the Justice Department that those aren't going to make it into the case somehow. And so it's been a total violation of due process and fairness in these proceedings. And a lot of this evidence, I think, if you had a country that wasn't a total failed democracy or state, would be throwing out this prosecution because it should be dismissed with prejudice.
I mean, Ellsberg's prosecution was thrown out because they broke into his psychiatrist's office and did other illegal surveillance. People have made an analogy between the surveillance you just described and what happened to Ellsberg. The courts were a little bit more skeptical of the government back then, so we'll see what happens if this reaches the U.S. I know you've been really critical of some of the coverage of the hearing, but I think one of the few aspects of the hearing that's gotten more traction, and I'm sure people watching tonight have heard about, are these claims about Donald Trump offering Julian Assange a pardon. Could you explain what the issue was there and what's your take on it?
So I think that the evidence is that Representative Dana Rohrabacher from California did have a meeting with Julian Assange. He did believe that he was capable of going back to Donald Trump in the White House to get Julian Assange a deal. But I don't think that there was ever any conversation where he discussed a pardon and was in a position to offer it to Julian Assange when he went in August 2017 to offer this pardon. This actually pops up related to the surveillance because we were told that U.S. intelligence sources were unnerved by the fact that this congressman was having a meeting with Julian Assange. But I think he was trying to make peace. He believed that the Russia allegations were tearing the country apart. And he thought that if Julian Assange could just reveal his source and tell people who the source of the DNC emails or the Podesta emails was, we don't even know. Then maybe they're different sources. I don't know. So could you reveal your sources? And of course, that's a very big ask. That's asking WikiLeaks to violate one of their, if it's probably the most important thing that WikiLeaks stands for, which is that we are not going to reveal any information about our confidential sources. Something you can understand if you have any respect for investigative journalism. And he didn't take the deal. He did not take the offer. But then afterwards, what the defense is trying to say is he rejected the offer to help Donald Trump, and then the department indicted him. So they're trying to create a cause and effect. I don't know if this is as persuasive as they believe it to be, but certainly cover all your bases as a defense attorney. You want to put before the judge, let her decide.
Yeah, it's defense that brought it up. So is there anything else from this trial that people watching should know about? And what are the next steps in the prosecution of Assange?
So there is one detail that I'll just mention very quickly because it is relevant. So there's an individual who's being held at the Supermax prison right now. His name is Mustafa Kamal Mustafa, and he's more widely known as Abu Hamza. He was convicted of some very serious terrorism offenses. But the reason why I bring it up is because we heard some very good testimony from attorney Lindsay Lewis, who is his lawyer, in terms of representing him because of mistreatment that he's been receiving. So people may know him. He's a double amputee. He has a hook for one of his hands, and if not both, and he's missing an eye. So it's possible people have seen him before. But the warden for the Supermax represented to the British court system that he was not going to be kept in the Supermax for a lengthy, indefinite period. He would be sent there, and then he would be evaluated. And likely because of his condition, he has diabetes, he has other health issues, he would be transferred to a medical center. Well, it turned out that that's not true. That was false, and he's still there. He's been at the Supermax prison for 5 years, and he is abused. No matter what serious crimes he committed, no matter what heinous acts he has been involved in or implicated in, he is being abused. And it, I think, was a really good example to put before the judge that the U.S. government is likely deceiving her in this case about the cruel and inhuman treatment that Julian Assange would receive. I can't tell you how many times they seem to deny the reality that Julian Assange will be treated like a national security defendant if he is brought to the United States. They seem to make it like they wanted us to believe that he would be treated like you're like a common criminal and not somebody who the U.S. government would give special attention to. And so I think that's an important point for me to add as we're getting closer to the end of our conversation.
And what are the next steps in the trial?
So we wait for the decision that'll be coming on January 4th. And then after that, once we know, we'll see where the process takes place.
And Kevin, if people want to learn more about your work, where can they find it?
So I've you can go to shadowproof.com, And then I have a newsletter that I'm running at Dissenter, dissenter.substack.com, where people could subscribe if they're interested. There's both free and paid content. And what that is my focus on whistleblowers, the larger war on whistleblowers, as well as providing WikiLeaks updates.
And I read it every day. It is must read information. Kevin, thank you so much for joining us. I know you joined us in March as well. It is always a pleasure to have you on, even if it's a very dark topic. Thank you so much for the courageous journalism you've done around the war on whistleblowers, around Assange. I know personally I would know so much less about not just the Assange prosecution, but Manning's court-martial and all of these issues without your reporting. I'm thankful you're out there, even if the New York Times is not interested in this story. And I would take you over the New York Times any day, Kevin.
Well, thank you. And thank you for the work that your organization does on civil liberties. It's really important.
And talking about the work that we're doing on civil liberties, if you're watching and you're really outraged by what you're hearing, you can go to rightsanddissent.org/takeaction. There are 2 bills before Congress this session about amending the Espionage Act. There's only been 3 bills to amend the Espionage Act for the better ever. 2 of them are currently before Congress. One is called the Protect Brave Whistleblowers Act, and it's been introduced by Tulsi Gabbard. It would address the issue of particularly whistleblowers who are indicted under the Espionage Act being unable to get a fair trial. When you are indicted under the Espionage Act, the only thing the government has to really prove is that you gave information to someone who wasn't supposed to have it. So if you're Dan Ellsberg and you gave information to the New York Times, if you're Edward Snowden, you gave information to Glenn Greenwald, that's end of the case. Ellsberg famously tried to take the stand in his own defense, and the judge stopped him from talking about why he had leaked the Pentagon papers because it was irrelevant. So what the Protect Brave Whistleblowers Act would do is, first and foremost, it would require the government to get an Espionage Act conviction. They would have to prove beyond a reasonable doubt that the defendant acted with the specific intent to harm the U.S. national security or aid a foreign power. It would create an affirmative defense that the document's disclosure was in a public interest, and it would allow the accused to testify as to the purpose of their disclosures. The second bill we're asking you to support, and if you go to rightsanddissent.org/takeaction, you can contact your members of Congress about both bills very easily, is the Espionage Act Reform Act, which was put forward by Representative Kahana and Senator Wyden. This bill would not help people like Snowden or Ellsberg or Manning, but it would be very helpful to journalists like Julian Assange. What this bill does is it changes the definition of covered persons under the Espionage Act, so it would only apply to those with security clearances, those who have signed non-disclosure agreements, or people who qualify as foreign agents under FISA. So journalists and members of the general public who don't have any obligation to keep classified information secret could or would not be covered by the Espionage Act. Both bills do something that you're probably surprised even has to be done. It makes it so that a whistleblower who gave information to any member of Congress, not just those select members of Congress with security clearances, but any member of Congress, so like a Daniel Ellsberg who gives information to Mike Gravel, or the Privacy and Civil Liberties Oversight Board, or a number of other oversight bodies, they could not be charged under the Espionage Act. I know what you're thinking. Cannot possibly be true that the Espionage Act is so poorly, clumsily drafted, overly broad, and draconian that if a government employee went to a member of Congress and gave them information about criminal activity, they could be prosecuted under the Espionage Act. Unfortunately, it is true, and both bills address that issue. So we are urging you to write your member of Congress. You can go to rightsanddissent.org/takeaction and tell them to support the Protect Brave Whistleblowers Act and the Espionage Act Reform Act. These are first steps. I realize there's a whole bunch of other problems with the national security state and with persecution of whistleblowers and the media, but these would be huge steps. I would remind you that when Chelsea Manning was court-martialed, she pled guilty beforehand to charges that carried up to 20 years in prison, but the government continued to pursue a court-martial against her for violating the Espionage Act and aiding the enemy. She was convicted of violating the Espionage Act, but even in a military court, which is not exactly known for due process or being friendly to defendants, they couldn't get her for aiding the enemy. So adding that specific intent requirement in is extremely important. Thank you everyone for watching. I urge you to follow Kevin's work. He's one of the best journalists there is at shadowproof.com. And I urge you to go to rightsanddissent.org/takeaction and tell your member of Congress whistleblowers and journalists are not spies. It's time to stop prosecuting them as spies. This is not something we do in a democracy. And with that, good night and good luck.